warm welcome to all of you, to all our participants and speakers, to the IUCN World Commission on Environmental Laws webinar on advisory opinions on climate change, initiatives, expectations, and possibilities. This webinar is part of the IUCN World Commission on Environmental Laws webinar series, The Transformational Power of Law, Addressing Global Environmental Challenges. My name is Christina Voigt. I'm the chair of the IUCN World Commission on Environmental Law and a professor of law at the University of Oslo in Norway. This webinar is organized by various parts of the World Commission on Environmental Law, in particular the specialist group on climate change law, chaired by Professor Francesco Sindico, and the specialist group on ocean law, chaired by Professor Cymie Payne, and the early career group, which is chaired by Marina Venancio, and we have two members of the early career group with us here today. We also involved the steering committee of the World Commission, represented here by Professor Nilufer and Professor Claudia de Windt. We are very pleased and very privileged to have you all with us here today. A very special thanks goes also to Mr. Ayman Cherkaoui, the Deputy Chair of the World Commission on Environmental Law, who put this webinar together, actually the entire series together, and will moderate it in due course. And special thanks also go to Mr. Roberto Cole, the Executive Officer of the Commission, who took care of the challenging logistics. Let me say a couple of words about the topic of today's webinar. We are currently witnessing a new phenomenon: climate change litigation having reached the international level, the level of international courts and tribunals. You all know that for several years we have seen a wave of domestic climate litigation, and we also have a couple of contentious cases pending at the supranational level, at the European Court on Human Rights in Strasbourg. But these are, as I said, contentious cases. They concern claims against particular states. But what we are seeing now, and what we'll be discussing today, is different. It's part of a bigger picture on climate litigation, but it's different because we are looking at requests for advisory opinions, for legal clarifications, or you could say authoritative statements by international courts and international tribunals on pertinent questions of international law with respect to climate change, where the law as established under the United Nations Framework Convention on Climate Change and the Paris Agreement do not give concrete answers. We have, for example, the request for an advisory opinion by the International Tribunal on the Law of the Sea concerning the questions: which obligations do states have under the United Nations Convention on the Law of the Sea to protect the marine environment? Or the potential request to the International Court of Justice for an advisory opinion on legal obligations to protect present and future generations against the impact of climate change. And the most recent request by Chile and Colombia that aims at an authoritative statement, at an advisory opinion by the Inter-American Court on Human Rights on various legal aspects of states' obligations under the American Convention on Human Rights. We will discuss these initiatives and their possibilities and expectations today with a number of WCEL members who are closely involved in these initiatives. Whatever the outcome may be, and we don't know that yet, it most likely will be very important to ensure consistency and coherence in the international legal system, in particular with the obligations under the United Nations Framework Convention on Climate Change and the Paris Agreement. The Paris Agreement will be relevant in all these proceedings and might inform the content of state obligations under the law of the sea, under human rights law, or general customary international law. In this way, some of the obligations of conduct contained in the Paris Agreement might inform the interpretation of legally binding obligations under other international law, and thereby might gain teeth. WCL is preparing submissions to the Inter-American Court on Human Rights, as well as to the International Tribunal on the Law of the Sea, on behalf of the International Union for the Conservation of Nature, where we aim to bring together science and legal expertise, a strength of the IUCN, where we hope to give input into these legal proceedings. It is now a great pleasure for me to welcome from the IUCN Secretariat, Dr. Grethel Aguilar. She is the Deputy Director General of the International Union for the Conservation of Nature, IUCN, a lawyer, and a supporter and friend of the World Commission on Environmental Law. Grethel, the floor is yours.
Thank you very much. Professor Christina, Voigt, and esteemed colleagues, ladies, gentlemen, friends, allow me to start by thanking the Commission for giving me this opportunity to speak on today's webinar. Advisory opinions, as we have heard so eloquently from Professor Voigt just before, are a tool with a great promise when it comes to climate change and also biodiversity conservation, which each passing month, conserving the natural world becomes more important on the global agenda. And we are seeing more efforts to hold states, companies, stakeholders to account, and to help them to take action in a coordinated way. However, as expressed before, advisory opinions also come with their own challenges. In the climate change space, there are still novel tools that have only really started to gain traction in the 21st century. And despite having no binding force, despite having no binding force, opinions can carry legal weight and moral authority. They are a new way for the world to continue promoting the role of the rule of law in delivering justice and achieving sustainable development. And because they're new, the international legal community has a responsibility to make sure that they are guided and used correctly. That is where IUCN comes in through the power of the World Commission on Environmental Law, the IUCN Secretariat and its membership. For decades, IUCN has helped to shape global legal frameworks to conserve nature and natural resources. We play a leading role in drafting the Ramsar Convention in 1971, the World Heritage Convention in 1972, CITES in 1974, and the Convention on Biological Diversity in 1992. We are an intergovernmental organization observer to the UNFCCC and offer our technical support to this framework that governs global action on climate and nature conservation. Fundamentally, we also create legal capacities around the world for developing and implementing environmental law at national and local levels. This is a process that continued to evolve and which was in full force just 2 months ago in Chairman Cheik at the Climate Change Conference, when IUCN directly took part in the Conference of the Parties with participants from the Commission and from the Secretariat and also IUCN members. Today, you will hear from experts, members of the World Commission on Environmental Law about different opportunities for advisory opinions. As IUCN, we should be very proud that some of the Commission members are taking a seat in the preparation of these opinions. These advisory positions can become great instruments to influence fundamental discussions at the country, regional, and international level. For example, Colombia and Chile presented a request for an advisory opinion to the Inter-American Court of Human Rights with the purpose of clarifying the scope of state obligations to respond to climate change emergency with the framework of international climate law and human rights. In many of the advisory opinion requests, countries are asking fundamental questions, as for example, how should the obligations of cooperation between countries be interpreted? How should states act to guarantee the right to reparation for the damages generated by acts or omissions that had caused harm to the environment, taking into account considerations such as equity, justice, and sustainability? Or, for example, what are the obligations of the states under international law to ensure protection of the climate change system or other parts of the environment? These are not easy questions, and it's not a surprise that countries around the world live the permanent challenges of confronting the climate change crisis. This crisis needs support and guidance on how to respond to these urgencies on the principles of justice, equity, human and environmental rights and obligations. The World Commission on Environmental Law has been part of these processes on various occasions. For example, and thanks to Professor Claudia de Windt and other commission members, the commission provided legal expertise for interpretations to the Inter-American Court of Human Rights concerning articles of the American Convention on Human Rights in 2017. Recently, as Professor Voigt has shared with us, the Commission has received new petitions of collaboration, and many of you are currently preparing IUCN submissions to the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights, as Professor Voigt just shared with us. We all know that advisory opinions can contribute to the interpretation and development of international law, helping society to live in harmony. In IUCN, as indicated before, we are thankful to the many of you members of the World Commission on Environmental Law and proud to be part of these processes. As discussed with Professor Voigt in diverse occasions, IUCN has a specific value. We can combine high-quality scientific expertise with the legal expertise that exists in the Commission. This is a huge opportunity that goes in line with IUCN mission. You know, IUCN missions start with two words, to influence. To influence, encourage and assist societies through the world to conserve the integrity and diversity of nature and to ensure that any use of natural resources is equitable and ecologically sustainable. In a nutshell, this is a great opportunity to see IUCN as its best, influencing societies with its knowledge and expertise. IUCN approach to climate change and to the laws behind climate change action shows deep knowledge that is married with innovation and flexibility. All of you here today are part of the IUCN community in one way or another, and that is the beauty of our union. I look forward to hearing your reflections and discussions on advisory opinions and to learning things that will help us conserve nature and bring benefits to people around the globe. Many thanks, gracias, and thank you.
Thank you so much, Dr. Aguilar. Thank you for your words of encouragement and support to our work. There is a lot of work ahead of us, and we are very much looking forward to closely working together, collaborating, of course, with the IUCN Secretariat and across the IUCN Union, the family, with other commissions and specialists in that endeavor that we are embarking on. Thank you so much, and thank you for being here with us today. It is now my great pleasure to pass the floor, the literal floor, on to my colleague, Mr. Ayman Cherkaoui. As I said, he is the Deputy Chair of the IUCN World Commission on Environmental Law and Director at the Hassan II Center for Environmental Education in Morocco. Ayman, the floor is yours.
Thank you very much, dear Christina. Greetings to everyone. Very happy to be part of this webinar that has a lot of interest, as we could see from the number of registrations, almost 1,000, and the more than 300 that are currently online. Very grateful for this level of engagement. Earlier, a dear friend Grethel referred to COP27 that was under the Egyptian presidency, and I realized I was refreshing myself holding the bottle from the COP27. I thought that was an interesting coincidence. Talking of coincidences, Christina also referred to a wave in terms of this climate litigation at the international level. So I think it is quite logical that the first session will be looking at waves in a certain way, and we'll be discussing in this first session the International Tribunal for the Law of the Sea in the context of the request for an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law. This session will be co-led by Professor Nilufer Oral and Professor Cymie Payne, that I'll be introducing shortly. Then this next session will be looking at the other element of interest to us today, which is the draft resolution on the request for an advisory opinion of the International Court of Justice on the obligation of states in respect to climate change. Each of these two sessions will be timed at approximately half an hour. We will have them an opportunity to exchange around question and answer. So the co-leaders of each session would have the opportunity to react to some of the questions that will have been identified by them. Then we'll move to our next session, the third session, where we'll be looking at the Inter-American Court on Human Rights, request for an advisory opinion from the Inter-American Court on Human Rights concerning the interpretation of Article 11, 41, and 51 of the American Convention on Human Rights for about 20 minutes. Then there'll be an opportunity for another Q&A, a shorter one, dedicated to this specific session. And the time for us will have come at that point in time to close our webinar for today. But as I will repeat later on, we'll be organizing later in the year dedicated webinars on each of these important opportunities. So without further ado, we'll be diving towards the first session on the International Tribunal for the Law of the Sea, request for an advisory opinion submitted by the Commission of Small Island States on Climate Change and International Law. This session will be structured as follows. First, we'll enjoy some scene-setting remarks from Professor Chhaya Bhardwaj, and then we'll be enjoying a discussion with the co-leaders of the session, Professor Nilufer Oral and Professor Cymie Payne. Professor Chhaya Bhardwaj is currently a member of the IUCN Work Commission Environmental Law Early Career Specialist Group. For all the introductions and the presentation of biographies, I'll be very short in the interest of time, as all of our eminent speakers have very impressive backgrounds that if I were to try to give more honor to, I'll be spending at least half the session of today exposing. Without further ado, Chhaya, the floor is yours. Thank you very much.
Thank you so much, Ayman. Good morning, good afternoon, and good evening to everyone. My name is Chhaya Bhardwaj. I'm currently a member of the IUCN WCEL Early Career Specialist Group, and I welcome you all to this very timely and important discussion today. It is a matter of honor for me to introduce and initiate this dialogue on the advisory opinion requested by the Commission of Small Island States on Climate Change and International Law from the International Tribunal for the Law of the Sea. Professor Nilufer Oral, member of IUCN WCEL Steering Committee, and Professor Cymie Payne, chaired IUCN WCEL Ocean Law Study Group. Both will enrich us with their dialogue on this topic today. Climate change is indeed a planetary crisis faced by all humankind. The small island states, however, are known to be particularly vulnerable to the adverse effects of climate change. Small island states are not in a position to change the course of the events in the world. What the humans do or do not do today will significantly influence the fate of the small island states and their people. With a vision for global climate justice, the heads of the government of Antigua and Barbuda and Tuvalu established an umbrella organization, the Commission of Small Island States on Climate Change and International Law, in October 2021. This commission was established under the agreement for the establishment of the Commission of Small Island States on Climate Change and International Law. The mandate of the Commission is to promote and contribute to the definition, implementation, and progressing development of rules and principles of international law concerning climate change. These include and are not limited to the obligations of states relating to the protection and preservation of the marine environment and their responsibilities for injuries arising from internationally wrongful acts in respect of breach of such obligation. The Commission is specifically dedicated to developing rules and principles of international law concerning climate change, in particular to the preservation and protection of the marine environment. In order to fulfill the Commission's mandate, Article 2.2 of the agreement notably empowers it to request advisory opinions from ITLOS on issues such as adverse effects of climate change on the small island states. Bearing in mind the fundamental importance of oceans as sinks and reservoirs of greenhouse gases and the direct relevance of the marine environment to the adverse effects of climate change on the small island states. The Commission submitted its first questions to ITLOS on December 12, 2022, which are, what are the specific obligations of state parties to the United Nations Convention on the Law of the Sea, the UNCLOS, including under Part 12, for two specific objectives. Number one, to prevent, reduce, and control pollution of the marine environment in relation to the deleterious effect that result or are likely to result from climate change, and B, to protect and preserve marine environment in relation to climate change impacts, including ocean warming and sea level rise and ocean acidification. Climate change today is the single largest factor that can be catastrophic to small island countries. By degrading marine environment, depletion of substantial marine living resources, consistent sea level rise subsequently endangers the very existence of small island nation states. The stakeholders need the rules and principles of international law concerning climate change, underlining their obligations to protect and preserve the marine environment and their responsibility to compensate for the injuries for any breach in their obligations, if at all. Further, the advisory opinion is one of the leading initiatives that will allow the small island states to voice their vulnerabilities, needs, challenges that are arising due to the adverse effects of climate change. We would all like to learn more about the importance of this advisory opinion from our esteemed jurists on this issue, Professor Oral and Professor Payne, who are directly involved with the work of the Commission and the submission of the application of the advisory opinion. Professor Grethel mentioned IUCN was also specifically invited by ITLOS to provide a written statement on legal issues involved, making this dialogue a very timely and important event. I would now like to give the floor to Ayman to introduce our co-leaders for the dialogue and formally invite them to the floor. Thank you.
Thank you very much. Much appreciated. Indeed, very helpful context setting for the important conversation that we follow. And as you rightly pointed out, we are very lucky to have with us both Professor Nilufer Oral and Professor Payne that are really instrumental in this effort. As I indicated previously, I won't be introducing as much as they deserve, both of our eminent speakers. I will be focusing on their relationship with the IUCN World Commission on Environmental Law. So Professor Nilufer Oral is a director of the Center for International Law at the National University of Singapore, and she's a member of the IUCN World Commission on Environmental Law Steering Committee. Professor Payne is an associate professor, and she's also the chair of the IUCN World Commission on Environmental Law Specialist Group on Ocean Law. So as you can imagine, very much at the core of the topic. So Nilufer, Cymie, would you like to perhaps react and comment on what you have heard so far in terms of sharing with us some insights and reflections? Perhaps, Cymie, I see that you're muted yourself. I think you're quite eager to go. Please go ahead. Very happy for your eagerness. Thank you.
Well, I'm always delighted to converse with my friend Nilufer. Maybe I should mention that Nilufer was the team leader for IUCN's response to the second advisory opinion that the Law of the Sea Tribunal had heard. And we participated, IUCN participated in both of the tribunal's advisory opinions. So we are really honored to have been invited to specifically to contribute again. What I would like to ask Nilufer is, why is this important? Why is this advisory opinion important?
Well, greetings to everyone, and just a collective greetings to all, and a really special thanks to WCEL for putting this together. And I'm delighted to be with Cymie here, and thank you, Chhaya, for setting the scene so very nicely. So just a little bit. Well, it's important in so many levels, but one, I have to say, as someone who's been a member of WCEL, dare I say, for nearly 20 years now, I think it is really important in many ways for IUCN to be part of this. And as you said, Cymie, that this will be actually the third advisory opinion for ITLOS that IUCN has been invited. Although this time it was a little different, actually. The first one was the advisory opinion for the seabed, on the seabed, on the sponsoring states responsibility, and the second was related to IUU fishing. I'm going to give it very short because the titles are always too long. And Cymie, you yourself were active in both of these, and now I'm really happy that you're taking the lead in this advisory opinion. It's important because, I mean, as Chhaya said, number one, climate change is a planetary crisis. And I think that we tend to think of it as climate change in the atmosphere, but it is having tremendous adverse impact on the ocean. And we can talk a little bit more later on, perhaps, about some of the gaps. But we're in an area where the ocean doesn't, and between UNCLOS and the climate change regime, there isn't an obvious direct link. So this advisory opinion from ITLOS, and we won't talk about Vanuatu, is a really golden opportunity to have some clarification on some of the issues that really are not clear in terms of what state responsibilities are, in terms of the ocean. We've talked about ocean acidification as one, ocean warming, sea level rise. These are all part of the climate change, the adverse impacts. So it's very important to get that clarification on state responsibilities, but also I think Chhaya was mentioning with the small island developing states, there are so many issues. This is just one advisory opinion, and there is only two questions, really. They're big questions, but I can assure you that I think there are many more issues out there that require clarification. But from IUCN's perspective, I think it's extremely important that the IUCN, which is the leading global conservation organization, the oldest, the largest. And may I say, WCEL is a unique commission of legal experts. And as Grethel said, and Christina said, it's an organization under one umbrella that can bring together the scientists and the legal experts. So I know we have limited time. Oh my gosh, it goes quickly. So Cymie, I want to ask you a question. This is a dialogue. And going more into the issue of the advisory opinion itself. And I think we have 3 advisory opinions. I don't think this has ever happened. Parallel advisory opinions. It's really exciting. And of course, they're all focusing on state responsibilities. But let me ask you, is it, how do you see the state responsibility under UNCLOS versus, for example, the Vanuatu Initiative from ICJ and also the Inter-American Court on Human Rights?
Can't resist being a professor here. So I have to say, I think I immediately think of each court's jurisdiction and the applicable law. And the law of the Sea Tribunal is a specialized court. It is primarily being asked, and it's embedded in the question, as explained in her introduction, that this is under the Law of the Sea Convention. So the first stop for the court will be to look at and interpret the Law of the Sea Convention. And then there'll be a question about what other international law the court can look at. So there's this interesting, Dr. Aguilar pointed out the complexity of the relationships here, that the, excuse me a second. I beg your pardon.
Are you okay?
I'm okay. I'm sleep deprived and I lost the thread for a moment. Not a good moment to do that.
That's all right.
So
take your time.
there is a contrast. There's a contrast between the legal frameworks that the other advisory opinions are presented in. And what I was struggling with in framing the statement is that the ocean is 70% of the surface of the planet. So it's a very dominant physical force, but it is not as dominant a legal force. And a great deal of the ocean, as we know, is even beyond national jurisdiction. So the evolution of the laws that have gone into climate change litigation have been terrestrially based. They've been within national legal systems. And this is really going to be one of the special issues for the Tribunal for the Law of the Sea to deal with, is this connection where the activities that are generating climate change are not primarily taking place in the ocean, but the ocean is the recipient of so much of that. And I guess one other thing I would say, where I would pick up with what Dr. Aguilar commented on, is the special role that IUCN has in this context of having a very deep scientific expertise as part of our team, as part of our role. So we will be bringing scientific experts to the tribunal through expert opinion to make sure that the basis for the legal concerns are well understood and well placed. So Nilufer, could you tell us a little more, in thinking about this problem that the Law of the Sea Convention is what the tribunal is focused on? How do we make the link, especially with the UN Framework Convention on Climate Change, with the Paris Agreement?
Yeah, that's a big question to make that link. It's a critical link to make. And this is really, I think, where the important role of these advisory opinions, particularly for the ITLOS opinion, will be. So we know that the Law of the Sea Convention, it's a great convention. Part 12 on protection of the marine environment is really quite broad and comprehensive. But it was a convention that was negotiated and adopted before climate change was on the international agenda. So it really doesn't directly address climate change. But the question is, are its provisions of a nature that it can be interpreted and clarified to apply to climate change? But what do we mean by that? Are we linking, first of all, I mean, there are issues such as the convention deals a lot with pollution. Is climate change, the greenhouse gas emission, carbon dioxide, pollution? But I think more when we look at the second question, which is broader marine environment, protection of the marine environment and state responsibilities, how does that link in then to, for example, the UNFCCC, the obligations under the UNFCCC for mitigation in particular, and then of course the Paris Agreement. And what we're missing is that, one, there is more scientific, the science is there linking climate change, greenhouse gas emissions to the adverse impacts on the ocean. And it's a carbon dioxide problem, principally, particularly ocean acidification. But what we need to have is linking the two regimes together through mutual obligations. So how do we link, for example, the obligation, the temperature goal under the Paris Agreement, which is critical, with the obligation to protect and preserve the marine environment under Part 12? What about in both Paris and the UNFCCC, it's in the should language, so it's hortatory, but it's about measures to be taken by states to sustainably manage reservoirs and sinks, which includes the ocean and marine ecosystems. So right now, what it looks like is the UNFCCC regime, those very limited references to the marine environment and ocean are a satellite separate from the Law of the Sea Convention, which has very clear, distinct, much more comprehensive obligations. So I think it's absolutely critical that through these advisory opinions that we be able to link these two regimes. We talk a lot about fragmentation, and with the BB&J, that was a big issue. And I know, Cymie, how involved you are in that. So it's an opportunity to kind of draw the links, the dots together, and drawing between the climate change regime, possibly others as well, but principally the climate change regime, the principles, the obligations, the framework to that under the Law of the Sea Convention, so that we have more harmony.
I think, it's interesting that with these opinions, it gives us a chance within WCEL also to seek the through line across those different legal regimes. And Nilufer, something else that you commented on reminded me that we have the Law of the Sea Convention. We also have the implementing agreements. So the 1994 agreement, it doesn't add much for this, but that little bit doesn't add much for this. But the measures dealing with responsibility of states in terms of deep seabed mining were well ventilated in the first advisory opinion, and the jurisprudence that provides on, for instance, obligations of due diligence, the relative obligations of states are very valuable in the interpretation of the new questions, but also there is the potential that the third implementing agreement, and the fish stocks agreement, of course, in the second advisory opinion, but the third implementing agreement may have an adopted text, if we're lucky, in March, and that may be an appropriate reference point for this opinion too, but we'll have to wait and see what we have.
Yeah, definitely. I agree. And
sorry to come in, but we might have to also wait and see to go into a bit more depth about this fascinating dialogue. If I may perhaps ask you, each of you to, in the interest of time, perhaps summarize in 30 seconds what would be a key takeaway from this conversation that we would need to go back to as we deepen our understanding in, we hope, upcoming webinar that will be dedicated to the issue. Thank you very much.
Cymie, go ahead.
I think one of the questions that will be very interesting, and particularly from the IUCN perspective, is the role of science in this. And that's in part because an advisory opinion is meant to not be about facts. It's not, that's a contentious case, but it's meant to be about the legal issues. But the legal issues here are illuminated by the facts. And this is where IUCN not only shines, but in conversations I've had with others involved in the advisory opinion, is what is hoped for from IUCN, that we will bring that together.
Yeah, and just very quickly, and again, time goes quickly. I have to say that, and one thing we could have talked a little bit more about is what would the advisory opinion specifically be able to add. The reason I say that, there's some are a little bit more hesitant about advisory opinions, but I think if you look at the ones, for example, the IUU fishing on this, and also on the seabed mining, they actually clarified important areas of the law of the sea convention that without the tribunal would not have been clarified necessarily. So I'm hoping we can see the same thing from this advisory opinion. So I'll just stop there.
Thank you very much. Much more food for thought, certainly, as we move forward. Thank you very much for this dialogue. I certainly enjoyed it, and I'm certain that our 341 participants also did. Going to the next session, the session 2, on the draft resolution on the request for an advisory opinion of the International Court of Justice on the obligation of states in respect of climate change. We'll have again about half an hour. There will be some sensiting, context reminding remarks by Susan and Samuel, who's an Indian lawyer and a PhD candidate. She's also a member of the IUCN Work Commission on Environmental Law, Early Career Specialist Groups. And then we'll be enjoying a dialogue that will be co-led by Professor Francesco Sindico and Professor Margaretha Wewerinke. So, Susan, the floor is yours. Thank you very much.
Thank you, Ayman. Good morning, good evening, depending on the time zone that all of you are joining in. So I'm Susan and Samuel, and I'm deeply honored and happy to be part of this important discussion along with Professor Francesco de Sindico and Professor Margaretha Wewerinke. And all the other eminent scholars who have joined us today, and I'm deeply happy about this. To set the scene, or to start off the session by setting the premise as to why we're here for, we will be discussing on the draft resolution on the request for an advisory opinion on the International Court of Justice on the obligations of state in respect of climate change. Now, this seems to be a huge wordy title in itself, but the essence of what we will be focusing is that although International Court of Justice have dealt with issues concerning the environment in the past, what is special is that the nexus between human rights, intergenerational justice, and climate change in itself has not yet been discussed or addressed. Therefore, the potential of an advisory opinion, a potential advisory opinion for climate change is immense, considering its initiatives, expectations, and possibilities. So what we can know is like a strong coalition of 16 member states from both global north and south under the leadership of a small island state of Vanuatu on the 9th of December 2022 presented a draft resolution containing a request for an advisory opinion to the court. So the court by means the International Court of Justice. So this makes us ponder over the different dimensions of political, legal, economic, and social implications that this draft resolution is bringing forth and the ripple effects that it can be happening. So for a brief history, since 2018, Vanuatu has been exploring the possibility of an advisory opinion. The initiative ever since has been gaining ground, and we're witnesses of this fact. The leaders of the Pacific Islands Forum in 2019 positively noted Vanuatu's proposal for a resolution requesting an advisory opinion to the International Court of Justice. Further, in September 2021, Vanuatu raised the possibility of a question being submitted regarding the duties of the state to protect the rights of the future and the present generations against the adverse effects of the climate change. Now, in the same month, it was reported that Vanuatu was leading a campaign to secure an advisory opinion from the International Court of Justice. So in October 2021, Blue Ocean Law, an international legal firm in Guam, announced that it would be supporting Vanuatu's efforts. And in May 2022, the Climate Action Network, representing 1,500 civil society groups from among 130 countries, backed Vanuatu's campaign, and this has been ever increasing. So climate change and its scientific validity, as we have heard earlier, because IUCN has been meshing this interdisciplinary aspect of how to grapple with the climate change, this validity of the protection of people and the planet, and considering it as an existential threat to the present and future generation, is immense. And this phraseology, like the present and future generation, has been repeated in the draft resolution. So such a rhetoric poses the urgency and the need for accuracy in measures to curb the climate crisis. And the emphasis of the protection of the present and the future generation of humankind is reaffirming the international community's prior goals. And we have been seeing that from many decades. For example, the Stockholm Declaration in 1972 and the Brundtland Commission in 1987, where our common future, and I've always been interested in our, because that is a radical inclusivity of all the people being taken part. And that means we, and in ourselves, the present and future generation. And the draft resolution was tabled during the 77th session of the UN General Assembly, requesting the court to provide an advisory opinion on the obligation of states under the international law to protect the rights of the present and future generation. Now, the interesting fact is that the concept of human rights has an important place in Resolution 2. So that is to propel the climate action as a different and more inherent strategy in itself. So this brings me to introduce the three focal questions, although posed as a singular one, addressed in the draft resolution, operative paragraph. The first question is, what are the obligations of the states under the applicable treaties and rules of general international law to ensure the protection of climate system and other parts of the environment for present and future generation? The second question that the draft resolution posed was, what are the legal consequences under the obligation of the states which have caused significant harm to the climate system and other parts of environment with respect to small island developing states and other states, for example, the vulnerable states, those who are under the risk of many hazards? And the third question is, what are the legal consequences under obligations for states which have caused significant harm to the climate system and other parts of the environment with respect to people and individuals of the present and future generation? So by this, I would like to open up the floor for the dialogue with Professor Francesco and Margaretha and Ayman after. Thank you so much. And maybe after introducing our distinguished guests, I would be happy to pose a few questions to them and evoke the dialogue onward.
Perhaps what I would suggest is you can just at this stage already continue with the questions you'd like them to address so that there can be a free-flowing conversation between the two of them as we just they had in the previous session. So I would invite you to already at this stage indicate the questions you'd like them to react to. Thank you.
Thank you, Ayman. Thank you. So Professor Francesco, I'd like to first address this question to you. Considering all of this of the potential advisory opinion and coming on, can you share some insights on how did we get to an advisory opinion? How did the campaign start? And what's unique about this whole dynamics or the whole thing? Over to you.
Sorry, perhaps briefly, do you have other questions, Susan? Maybe if you could just go over all of them so that then they can, Francesco and Margaretha can focus on the ones they want to address according to the flow they would like to have.
All right, sure.
Yeah, please. Thank you.
So after this question, maybe Margaretha, can you be able to answer, considering the developments of the potential advisory opinion, what stage are we now in and when we can finish it? And maybe after you both answer this, I will go to the next if we have time. Thank you.
Thank you very much, Susan, for your context setting and already sharing some fascinating questions to both expert speakers. So I'll be introducing them again very briefly so that we can enjoy as much as possible their insights on this important issue. So first of all, Professor Francesco Sindico is a carbon neutral island lead with the Scottish Government Islands team on secondment from the University of Strathclyde Law School. He's also the Deputy Chair of the IUCN Work Commission Environmental Law, Climate Change Law Specialist Group. Professor Margaretha Wewerinke is Associate Professor of Sustainability Law at the University of Amsterdam, and she serves as the lead counsel for Vanuatu in his pursuit of an advisory opinion from the ICJ on climate change, and she is a member of the IUCN Work Commission on Environmental Law, Climate Change Law Specialist Group. In addition to the questions that were identified by Susan, if I may also identify a couple for your consideration. First, in your from your perspective, what would be the best case scenario in terms of what you would like the court to say? And secondly, how likely do you believe it is that they will say it? Thank you very much.
So I think I'll begin. Thank you very much, Susan. Thank you very much, Ayman. And a huge thanks to everybody involved in the IUCN World Commission on Environmental Law for making this happen and for inviting me. As often happens when you also work for a government, that we caveat, everything I'll say is in my personal capacity and does not represent Scottish government. You asked me about the origins of the campaign. I will be very brief because I think it's also worth going into more the substantive legal stuff afterwards. But I do think it's important to highlight the power of youth and the power of students and the power of innovative projects within university. We obviously now talk about this being led by Vanuatu, and clearly it is, and Vanuatu must be commended for the amazing diplomatic efforts it's doing. But this goes much more in the past. My understanding that this was a cohort at the University of the South Pacific, and at some point, I don't know exactly the details, but they decided to put their attention on previous potential requests to the ICJ back in 2011, 2012, and understand why they failed and try to make it happen again. And fast forward 4 to 5 years, this is now what we have in front of us. So I'll stop there because obviously one can say more about it, but it's really about the power of youth not taking no for an answer and actually pushing things forward. In relation to Ayman's question, I think maybe Margaretha and I can come back to that later once Margaretha, if she can, she wants to explain to us, where are we now? What's going to happen now? Are we at the end of the story? Are we going to ask the ICJ today, tomorrow, in 5 months? So I'll leave that to you, Margaretha.
Thank you very much, Francesco. And of course, a very big thank you also to WCEL for putting this event together. It is special thanks to Ayman for all of the organizational efforts, and thank you also to Christina for your vision. I think this event very much shows the strength of WCEL. If you only look at the diversity of people that we have gathered here from all regions, from all career stages, with different legal expertise, and as you rightly said, Christina, of course, IUCN itself has also such a wealth of scientific expertise, and that makes, I think, IUCN a very important actor in these initiatives for advisory opinions. So it's very fitting that we are here together, hosted by IUCN WCEL. I also want to thank you, Susan, for your wonderful introductory scene-setting remarks. And so, yeah, let me delve in then and go to the question of where we are. I think Francesco already rightly pointed out that the origins of this initiative lie in Vanuatu, but not with the government, with law students at the University of the South Pacific School of Law, which is based in Vanuatu. So it's really not a coincidence that it's Vanuatu leading this initiative. So it was in 2019 that students really decided that this initiative needed to be pursued. In their words, it was time to bring the world's biggest problem to the world's highest court. And so they lobbied Pacific leaders. It was put onto the agenda of the Pacific Island Forum. Vanuatu then decided formally to take it on and convened its first diplomatic meetings around the initiative in 2019 in the margins of the Climate Action Summit. Now, fast forward, Vanuatu gathered political support from various key groups, the CARICOM, the Organization for African, Caribbean and Pacific States, the Pacific Islands Forum, and then also put together a core group, a cross-regional core group, to which you, Susan, already referred, which was asked to work with Vanuatu on a consensus text of the resolution, a draft resolution. So Vanuatu provided the first draft of the resolution to the core group, and the core group then worked on it and then presented this draft text to the UN membership last year. It was also then put on the agenda, as you know, the agenda item that discusses the annual report of the ICJ. Then a series of informal consultations were held. All UN member states had the opportunity to provide written inputs into the discussion on the draft text, and also orally provided suggestions during meetings at Vanuatu with other core group ambassadors convened at UN headquarters in New York. All of that feedback was again considered by Vanuatu's legal team, but also by the core group again, and all of the ambassadors and legal experts. That led to, again, several rounds of discussions within the core group. Those discussions concluded last week, Friday last week, and Monday, so 2 days ago, the core group led by Vanuatu presented a new text that incorporates a whole range of feedback from different UN member states in that text. So that was formally communicated to UN member states, and you can also consult the drafts on Vanuatu's campaign website, which is vanuatuicj.com. So if you go to vanuatuicj.com/resolution, you will see there the latest draft. Now, what lies ahead of us? That is another round of informals during which UN member states can again provide feedback on this revised text that will then again be considered and as much as possible incorporated, of course, to the extent that it strengthens the text. And then the planning is that the final version of the resolution will be uploaded onto the UN e-portal during the second week of February. And that means that it should be possible then to have the resolution being adopted in March, if all goes well. So that is where we are. And then, of course, as you all know, the request for an opinion will be communicated to the Register of the Court. You will also be aware that the court is not obliged to accede to the request. It is discretionary, but there are very good reasons to believe that the court will actually agree to provide the opinion. As you know, it has always done so in the past when requests for opinions were made by the UN General Assembly. And as you will also be aware, the UNGA can ask for advisory opinions on any legal question. So it is not restricted in a substantive scope as such. So yeah, there's actually no reason to think that the court will not provide the opinion. Then where it gets really interesting is, of course, the substance. So what
can we expect? And of course, what the ultimate opinion will look like will depend on a range of factors, but a very important one is the question to be posed. So we have a draft resolution, but it's still evolving. And so what that final draft is going to look like is going to be a significant factor in what we will get from the court. But it's not all about the question. It is also about the process. So as you also know, all UN member states and also international organizations can make submissions, written and oral. At least the oral hearings will most certainly be requested. So there will be hearings. And during this process, UN member states can also guide the court as it deliberates and makes up its mind about what the answer to the question should be. So all of that input is also going to weigh in and shape the opinion you may expect. Now, then the question about best case scenario. I really like the question about the worst case scenario. Well, what do you think is the worst case scenario? Because here we can appear very optimistic, because the worst case scenario is probably that the court is going to deliver a vague opinion. That's what we think is the worst case scenario. So it's not that terrible, because you can also speculate that the court could, well, decline to provide an opinion in the first place. Theoretically, that's possible. The court could provide a terrible opinion. It's very unhelpful. That says, for example, there are no obligations. But we think these risks are so small, given the need for an advisory opinion on climate change at this point in time, the need for the court to weigh in on this problem. The courts, the ICJ being the only UN principal organ of the UN that has not yet said anything about climate change, with the exception of one dissenting opinion. And so, plus, of course, just technically speaking, the jurisdictional risks are very small. And so we think, and plus, of course, signals that we are getting from the legal community in The Hague, we think that the court is very unlikely to be extremely unhelpful. But the question is, how helpful is the opinion going to be? And there, so we think worst case scenario is a very vague opinion, and the best case scenario is an opinion that is very clear and that really, once and for all, does away with the myth that you hear sometimes, till that climate action under the now today, because of the Paris Agreement, under the Paris Agreement, is all a matter of states' discretion. It's all a matter of voluntarism. We have lost a system with legal obligations that existed on the Kyoto Protocol. Under the Paris Agreement, anything goes, basically. And of course, that's not correct. And a few lawyers would even argue that, but still, it does prove challenging still to hold states to account for their climate action or inaction. We are off track. We are not on track for keeping temperature rise below 1.5 degrees. The level of ambition is still really falling short. And so there is a need for clarity about the obligations of states, and also a bit of a political boost. So the best case scenario should take account of the formal outcome. What is the court going to say, and what is the legal significance of what the court is going to say? But it's also about the political signal that the court can send about the need for greater ambition, and also the signal that is sent by the impact of a case that is led by youth and small island developing states, and amplifying those voices, and so also the symbolic value of the highest courts in the world pronouncing on this problem and articulating obligations. And there we can talk specifically about the role of human rights there, about intergenerational equity. But I think I should pause here, because I'm actually very curious, Francesco, what you would say about perhaps the worst case scenario and the best case scenario.
Thank you, Margaretha. I'm going to try to keep it brief so that we can open it up also for question and answers from the audience. I see a lot of questions in the Q&A. I think what could happen is for the ICJ to clarify 3 key areas, which are currently somewhat confused, if you want. The first, if you look at the revised question, which, as you said, just came out 2 days ago, the first area is when the question talks about obligations to protect the climate system. And then if you look at the second question, it focuses on obligations that, well, the legal consequences if the obligations cause significant harm. So significant harm is something that in international law has always been very subjective to some extent. If you look at international water law, there's a lot of obligations to not cause significant harm, but the ICJ usually and courts in general do not go into what exactly significant harm means. So it will be interesting if the ICJ is given this opportunity, will it go beyond the general statements, or will it actually explain what it means by significant harm, what it means to protect the climate system? And this is where I think the role of science, and I saw a few questions about the role of science, becomes incredibly important, and it's very much intertwined with the conversation we've had with Cymie and Nilufer before on ITLOS. And some of the people in the question and answer say that ITLOS may be a little bit more progressive than the ICJ when it comes to science, use of scientific experts, and so forth. So that's the first part that ICJ could clarify. The second one is about this idea of identifying the legal consequences. And I think that is where, as Margaretha rightly said, at least in principle, the ICJ could just say, no, I'm not going to answer this. Never happened. The only time it happened was with the Permanent Court of International Justice before the ICJ. The ICJ could potentially modify the question a wee bit, let's say. Again, that's very unlikely, but it could potentially. But I do think the second clarification, which is an interesting one, but a challenging one, is to ask the ICJ to clarify the legal consequences, and not just legal consequences, generally speaking, that could be state responsibility, but it goes, the legal question as it currently is framed, goes and actually says vis-a-vis whom? Vis-a-vis those states who breach the international legal obligations, clarified before, and those countries who are suffering the negative consequences today and are particularly vulnerable to that. I mean, think about it. To some extent, depending on how you interpret this, it can create an hypothetical bilateral scenario of one country doing something and another country suffering it. This will be open to interpretation, I think. And this will be very interesting if the ICJ is able to clarify that specific legal consequences. And this is where, again, some of the questions in the Q&A that we're talking about, who cares about all of this? Because then there's no enforcement. It's not, you know, all these ICJ stuff, and then countries do whatever they want from a political perspective. Obviously, one has to be nuanced there, and it's not all black and white. But it will be interesting to see, and this is more what happens after the ICJ advisory opinion, how can the ICJ opinion and the Inter-American Court of Human Rights and ITLOS push those political boundaries, push even the Paris Agreement into more compliance, into more willingness to actually raise the ambition. All of this is about raising the ambition, I think. And the third thing, and I'll finish there, is about this idea of clarifying rights for present and future generations. What does future mean? Generations in 10 years, 20 years, 50 years, 100 years? Again, the role of climate science comes in depending on 10, 20, 50, 100, modeling and so forth. And again, who knows what the judges at the ICJ will consider for future. Obviously, all the states will bring their own longer term, shorter term ideas, but I think that will be very interesting for the ICJ to clarify. So this is the best case scenario. The worst case scenario, I think, going back to the origins, the campaigning, yes, this is about law, but this is about campaigning. Those behind this, and I think this is a great thing, have plan A, B, C, and D quite lined up. So I think they are ready with whatever option and outcome happens. I'll give the floor to Ayman.
Thank you very much. Talking of the future, but a very short-term one, as we need to move to the Q&A session. I would like to ask each of you, in the same spirit that I did earlier with Nilufer and Cymie, if you could very briefly identify one or two central questions that you believe we should look into in more detail in an upcoming webinar that will be dedicated to this very important opportunity later this year. Thank you very much. And then we'll open the Q&A. As was indicated by Francesco, we already have quite a healthy amount of questions that are quite thought-provoking. Francesco, then Margaretha. Thank you.
Two suggestions. The first is look back at past ICJ jurisprudence and explore how that jurisprudence and potentially jurisprudence of other international courts may be relevant in answering the question as it is currently formulated. The second one is more forward-looking. Yes, we are talking about international tribunals, but I believe here the potential impact will be on domestic climate change litigation. So there's been a wave, whatever you want to call it, from 2015, especially after the adoption of the Paris Agreement. This is just going to grow. And it will be interesting to see that interaction between international dispute settlement and national courts.
And I would add to that another question, which is the relationship between these proceedings and the ultimate advisory opinion from the ICJ on the one hand and the climate negotiations on the other. This is much discussed also right now amongst UN member states who share thoughts and views with Vanuatu and other core group members on the process, and also share hopes, but also concerns. And a concern is often that an intervention from the ICJ could adversely impact the negotiations. And the hope is that it could actually bolster the process. Some would even go as far as saying it could save the Paris Agreement, because the Paris Agreement is failing to deliver on its own stated goals. So those who are very hopeful and optimistic think that an intervention from the ICJ could really help in boosting ambition, especially as states revise their NDCs, and the ICJ could provide benchmarks, minimum standards, if you like, that could lead to increased ambition, and ultimately then brings the world more, or actions more in line with the pathways that we know must be followed to meet those goals. So against that background, it would be very interesting to explore not only then the potential impact of an intervention from the ICJ on mitigation ambition, but also looking at the other pillars, if you like, of the climate change regime. So that includes, of course, loss and damage is also much discussed in connection with the question, because the question, of course, has two sub-questions, and then the second one focusing on the legal consequences of breaches of obligations. So there is, of course, a potential synergy with discussions on loss and damage, including in connection with the newly established loss and damage finance facility, where there are also questions about who will benefit, who will pay, etc. So what are the relations, how do these discussions or proceedings connect with one another? But then also the perhaps less often discussed potential synergies between discussions about finance obligations. Of course, you know, these are also very much existing obligations under the UNFCCC Article 4, on the Paris Agreement Article 9. What value could an ICJ advisory opinion have for discussion on finance? And the same goes for technology transfer, even, I think, less discussed than these other issues. And then even capacity building, we can look at their discussions about human rights, of course. There's a preamble reference to human rights in the Paris Agreement. Could an ICJ advisory opinion bring more life to that reference? So those would be my suggestions.
Thank you. Thank you very much. Quite a few suggestions, a lot of food for thought. We heard a lot about science in the session so far, and I believe, Nilufer, Cymie, there was a question from Professor Gehring that caught your attention. If you'd like to address it, we have about 15 to 20 minutes maximum for this Q&A session before we move to the third session. So let's try to take a few reactions first from Nilufer and Cymie, and then from Francesco and Margaretha, that will have to leave shortly because they have other time commitments as well. So Nilufer, Cymie, the floor is yours. Thank you.
I guess we'd thank Professor Gehring for the way he phrased his question, because I think the first part of the question is quite pertinent. The idea that there may be different understandings of science and law, the science and law interface in the three different fora. And that goes to the question of IUCN having a consistent view that we're presenting across our submissions. We have the opportunity there and also the need to be putting the science in the context of the legal framework for each forum, but that it's meaningful across all three. And we also have to be mindful that our definitions of key terms aren't simply valid for climate change, but will be valid for less apocalyptic scenarios where a small ecosystem might be in question. So when we talk about significant harm or defining pollution, that the definitions that we propose will be useful for the future as well. And I guess another thought is the question of what is the position of IUCN with respect to each advisory opinion request, whether IUCN will be invited to participate or not in each forum. So that is for the others to answer. Nilufer, you're...
Yeah, thank you. Yeah, thank you, Marcus. And it's great to know that you're in the audience there. Marcus himself is a great expert on climate change as well. And it is a good question. And just adding to Cymie, of course, here Marcus is kind of putting the spotlight on ITLOS as perhaps more scientific, science-friendly. And so, but I hate to get into a comparison amongst the different courts and tribunals. On the other hand, perhaps to some degree, because the Law of the Sea Convention devotes there is so much science in the Law of the Sea Convention. And for that reason, that is something that has been an integral part of the negotiation and development of it. The cases, of course, before ITLOS have been more restricted and limited. But I have to say that I did find a wonderful keynote speech by Judge Payne talking about technology and science and the use of it by ITLOS. And I think that I would agree that that the tribunal would seem to be very open to scientific information. And I'm not sure the more than others, but we know that there has been criticism about the ICJ and its lack of use of experts, relying on experts as provided by parties, and yet they can have their own experts. But I don't want to go into a strict comparison there. On the other hand, you know, how will science be presented? It is absolutely important, and I totally agree with Cymie and what others have said. This is one of the strengths of IUCN because it has decades of built up credibility. But we have the IPCC, and I would think that the IPCC reports would be, you know, kind of taken as fact and not be questioned at all. So it's just a question of having to link in areas that may not be covered by the IPCC, such as pollution or what is significant harm. You know, these are things. But anyway, I stop there because I know we're running out of time. But thanks again for that question.
Thank you very much. I'd now like to revert to Francesco and Margaretha to ask them, looking at the questions from the Q&A that were expressed through the digital tool on the Zoom platform, if there were a couple that they would like to address. at this point. Perhaps Francesco, then Margaretha. Thank you.
Thank you. I saw one from another WCL member, specialist, climate change law specialist group, Nadia Sanchez. She asks what could be the synergies between the advisory opinions. And I think that's an interesting, it's almost like having a calendar in front of you and see what comes first. So if you look at the ICJ one, it's broader and it looks at, I wouldn't say all international law, but yes, all international law obligations that could relate to climate change, of which obviously the law of the sea is one. So I do wonder in an hypothetical scenario where ITLOS comes out with its own advisory opinion clarifying what the law of the sea says on climate change, well, you could see the judges of the ICJ say, well, that work is done. I don't need to look into that. Whether they'll do that or not, I don't know. But you will start seeing part of that. So it's a question of timing. It's a question of how much judges from different courts are receptive to other courts. And there's a bit of speculation there, a bit like Nilufer said, it's a bit of a difficult game to foresee the crystal ball exercise. But clearly there's a timing element, and it would be sensible to think that there should be some positive cross-fertilization, although some other colleagues in the Q&A have said, what if? What if they start saying different things? And that would take us back 20 years with all the discussion, even academic, conflict of norms, conflict of jurisdictions, and then what happens, and so forth and so forth. So let's hope it doesn't take us back 20 years, but actually having 3 extremely authoritative statements, 2 at a global level, 1 at a regional level, can really push and raise the ambition, which is what we all want at the end of the day. I'll stop there now, Ayman.
Thank you very much. Moving forward and raising the ambition. Margaretha, would you like to react?
Yes, there are a lot of very thought-provoking questions being posed. It's difficult to choose one, but I see actually 2 really good questions that have been posed by Ademola Jegede, who is a very well-known human rights expert from Africa. And the first question is, what role can actors in Africa play in this strategy? And so here, it's important, I think, to emphasize the significance of the endorsement of the initiative by the Organization for African, Caribbean and Pacific States, which includes dozens of African states, and also the conversations that Vanuatu has had with the African Union and its member states in New York. So there has been strong support, generally speaking, from African states, also from civil society, African climate activists and law students and lawyers have been very engaged in the World Youth for Climate Justice, which is kind of the umbrella under which many civil society actors and organizations from around the world have organized themselves in support of this campaign, and also in influencing of it, of course. And then another related question is on loss and damage. So how about loss and damage, how does it relate to state obligations? That's of course a very important question. I already touched upon it. So we have, after about 3 decades of discussions, now reach an agreement internationally that there will be a loss and damage finance facility, which is really a breakthrough in the international discussions. But of course, many questions remain unanswered when it comes to its operationalization. And it may help if the ICJ provides insights into the substantive content of obligations that are particularly relevant when we speak about loss and damage. And those are, of course, substantive obligations drawn from different areas of international law, but also secondary obligations, as you may call them, that result from a breach of those primary or substantive obligations. So very broadly speaking, on the general international law, those obligations include obligations to cease the wrongful conduct. So that means basically to just start complying again with the obligation that was breached. And then also obligations to make reparations for injury that was caused by the breach. Again, a lot of questions that are triggered by even just talking about the existence of these norms in connection with climate change, legal questions as well as scientific questions about attribution, for example, causation, etc. But gaining greater clarity is going to benefit in the end all UN member states, not only those who are affected by who suffer loss and damage directly, but ultimately all UN member states, because this question of loss and damage now is slowly also being litigated. Of course, most climate litigation so far has focused on prevention, on harm prevention, but we see some cases now that start to engage with this question of responsibility for harm. And then we're talking about responsibility of states, also responsibility of corporations. Of course, the ICJ is not going to pronounce on the obligation of corporations, but there are obligations of states that are very relevant to understanding what the obligation of corporations may be, or responsibility of how corporations can be regulated in ways that help advance the situation of loss and damage. And so this clarity, it could help those who try to litigate this issue, but much more importantly, hopefully it will help to advance the multilateral discussions on it, because there's ultimately solutions on loss and damage will only be fair and effective if they are multilateral solutions. So litigation is always, I think, second best option. So hopefully the ICJ, being the principal judicial organ of the UN, will provide this clarity that really no domestic courts or other domestic or regional body can provide.
Thank you. Thank you very much, Margaretha. And as I'm speaking from Africa, from Morocco particularly, I'd just like to also indicate and strengthen the point that you made regarding the fact that Vanuatu is working together with a core group of nations, including several from Africa, such as Morocco, also Sierra Leone, Angola, Mozambique, and Uganda, if I'm not mistaken. Thank you very much for that, Margaretha. As we still have a few minutes left in this particular Q&A, I would like to revert back to Nilufer and Cymie if there were other questions that they saw in the Q&A and they would like to address, and also seize the opportunity to thank Francesco and Margaretha for having joined us today at this session. Thank you very much for your insights and your openness and your impressive expertise as always. And we have a bit of a rendezvous close for another webinar later in the year on this important issue. Thank you very much. Cymie, but maybe Nilufer first, if you'd like to react, as before I think Cymie started. Nilufer and then Cymie. Thank you very much.
Well, there's so many questions here, and I'm just looking at those. I think there's one about from Hector Medina, and he asks about the issue of fragmentation. So there's questions from a legal perspective and ultimately the governance perspective. How will fragmentation and the diverse competences of courts and aims and purposes of these specialized treaty regimes affect how the advisory opinions are shaped and also potentially received? I won't read the entire question. I think we've kind of touched upon these, of course, but I think that is an important question. We talk a lot about fragmentation, and I'm hoping that, you know, to me, I think it's just remarkable that we have these three parallel, and we still have to hear, of course, from the Inter-American. I'm looking forward to that. Parallel advisory opinions under different, well, of course, the ICJ one encompasses many, many, many instruments. The COSIS is directed to UNCLOS and could possibly also bring in other ones as well. Of course, we have the Inter-American. But ultimately, we would like to think that they would play a role. They're not going to coordinate, of course, the different tribunals, but we would hope that it would be a circle that's created by these, and not, I would say, a mosaic. I mean, that going to Margaretha's, what would be the worst outcome? Would be inconsistencies, really, and we don't want that at all. So I think that's an important question, and we'll see. It's an opportunity to bridge the so-called fragmentations, to really link in, and I think this is a theme that we all know from environmental law and other issues. I think we've seen now that between environmental and human rights, there's that linkage that's happening, that's happened with the recent resolutions, so important. So anyway, I'll just stop there.
Thank you very much, Nilufer. Cymie, please.
I think on the same theme, and it really goes to how influential can advisory opinions be if the different courts and tribunals speak with more or less one voice, but situating the important statements within different frameworks of international law, they strengthen each other. I'm hoping that there's a motivation within the courts and tribunals for the judges to want that result. But I think in terms of our obligation as having the opportunity to submit to them, another part of our job, in addition to making the science accessible and well-linked, well-interfaced with the law, is to help them do that. And so again, the WCEL community gives us an enormous strength in not being siloed. And I didn't do this at the beginning, but this is really the right moment, to my mind, to thank Christina and Ayman for bringing us together for this cross-fertilizing talk.
Thank you. The pleasure is all ours, very much so. Thank you, both of you, for your openness, your candor, and your engagement on this, and your leadership, your thought leadership on this important issue. Much appreciated. And as you saw as well in the Q&A, there are also expressions of interest in terms of engaging with this work going forward that I think it is important for us to build on as a community. The time has come for us to move to our next session, but certainly not the least. Session 3, which will be on the Inter-American Court on Human Rights, request for an advisory opinion from the Inter-American Court on Human Rights concerning the interpretation of Articles 11, 41, and 51 on the American Convention on Human Rights. This particular session will be led by Professor Claudia de Windt, who's a member of the steering committee of the IUCN World Commission on Environmental Law. I believe she has a picture to share, if I'm not mistaken. The floor is yours. Thank you very much, Claudia, for being with us. We can see the picture. I confirm that we can see the picture. We cannot hear you currently.
Can you hear me now?
Yes, I can hear you
Okay.
now. Thank you very much.
Great. Well, thank you so much, Ayman. I will start with a thank you to you and Christina for your leadership in this, and to Grethel Aguilar, who is also here. It's wonderful to have her had opened this webinar and talk about IUCN's role, especially being from the country where the seat of the Inter-American Court is. And what I was going to say is that it's so, after such a rich debate, it's so hard to figure out where to start. And I think the picture sort of gives me a good point of starting, which what we're seeing here, it's an illustration by two Spanish artists that was exhibited in the European Court of Human Rights last year on occasion of World Environment Day. It was drawn describing in drawing law for the Anthropocene, the advisory opinion 23 of the Inter-American Court, to which IUCN contributed between 2016 and 2018, which is an emblematic opinion issued by the court. And I think that the message that we have there addresses the issue of synergies that has been referred so much by my dear colleague Cymie and Nilufer. It says here means everywhere. And this is the approach that the court took in that advisory opinion. And I think where I should begin my short remarks saying that we have a baseline. in this case, and it's an important baseline. Of course, everything has a behind the scenes, which also leads to mentioning the connection between the role of all these international courts. Advisory Opinion 23 really started with a judgment of the ICJ in the case between Nicaragua and Colombia with regards to the San Andres archipelago and the distribution of the maritime territory and the land between those two countries done by the court. The question that the Colombian government posed had to do then with the interpretation of the three same articles that are being used as a basis for this new request by Chile and Colombia of the Pact of San Jose, the right to life, the right to personal integrity, and the obligation to respect rights. But in that moment, the question posed to the court was whether not complying with an environmental agreement, the Cartagena Convention on the Protection of the Marine Environment, would be a violation of those articles under the Pact of San Jose. And what was behind the scene was large infrastructure extractive projects in the shores of those islands of San Andres, and the implications for human rights and the local populations there. And what the court did, it's very interesting because it expanded the scope and of the question, and both substantively and geographically. It said that the scope could not be limited to one environmental agreement. It had to be applicable to all MEAs because of the importance of the environment and the situation that the world was going through at the moment and continues to go through with regards to climate change. And also geographically, it said that given the nature of advisory opinions, which has been discussed extensively this morning, how the court pronounced itself had a general interest that was not only for a given state or the state asking the question, but it was applicable or relevant for all states that have a stake in the planet. So I think that that was a very interesting contribution. The other thing that the court did was outline 8 obligations that are considered the obligations of states with regards to environmental protection and the connection with human rights, and established that the right to a healthy environment is an autonomous right. It doesn't depend on a lack of guarantee or affections of other human rights. And it opened the door for the possibility of the court hearing contentious cases on environmental rights, which had not been possible before. So I say this because all of the issues that the court discussed are looked upon in this new request, which is focused on state obligations in response to the climate emergency. And the background here is a resolution that comes from the Inter-American Commission on Human Rights on the emergency, the climate emergency, and human rights. Of course, the commission is not the member states and it's not the OAS. So to who that resolution applies to is very different than if it were an OAS resolution, than if it were the results of an advisory opinion, which are also relevant issues. And also the backdrop is the participation of Chile in the Santiago network, the loss and damage mechanism, and some local Supreme Court decisions that are there. And in the case of Colombia, we also have the decision on the Amazon and climate change. There are 6 topics that are being addressed in this new request. The first one has to do with state obligations with regards to the duty of prevention and protection with regards to human rights, the right to life and survival in the context of what we have, what the world knows now with regards to science, which is a topic that has also been addressed today. The third one has to do with common and differentiated responsibility in the context of human rights. The fourth has to do with the procedure of consultation, which was, as I mentioned, addressed extensively in the previous advisory opinion. And an innovative question has to do with judicial proceedings with regards to the climate emergency. And also another topic of the questions have to do with the rights and with regards and obligations to environmental defenders and the rights of children. And here, what the Committee on the Rights of the Child has done, including the newly issued general comment and what has done by that treaty body on the rights of children in the context of climate change, is extremely relevant, and other developments in the region on the principle of intergenerational equity. So that's what we have on the table. Those are the questions, 6 topics, more than 18 questions under all those topics, drilling down on what was said by the court before. And I would like to sort of close so that we can have opportunity, and in light of time, with what can we expect based on what we've seen before and the work and the contribution that IUCN provided to this whole process. And the first thing I will address is timetable. The relevance of these advisory opinions, in my view, is that they're more expeditious than a contentious process. In the case of Advisory Opinion 23, we have a request in March 2016, a hearing on November 2017 with 47 expert observations and 4 coming from states, among those the WCL observation, and an opinion issued in February 2018. So 3 years. Just to put that in perspective, one of the contentious cases that the court is going to hear, has heard in hearing very recently after the Advisory Opinion 23, took 16 years in the system, the case of Loroya, to get to the court or before the bench, to put it in a way. So in a relatively short amount of time, we have a lot of clarity on many issues. The 2 countries working together on this request have said that their motivation is to have clarity on inter-American standards. What we've seen is jurisprudential dialogue, because we have seen rulings from domestic courts that cite ad verbatim the findings of the advisory opinion. We see dialogue amongst the system of sources of international law with regards to the principles that were used in the advisory opinion, including some that were highlighted with the IUCN observation, of which, by the way, Nilufer was a very important part of our team, like Principle 19 of Rio, Principle 10, and so forth. We also have more coherence between the national level, the inter-American or hemispheric level, and the global level, because of the interconnections made to MEAs like the Paris Agreement and the use of concepts such as the concept of climate justice that was used there by the court. The court has a lot of latitude on these opinions, which is important. And I think that having the baseline that we have and the precedent with Advisory Opinion 23 brings up a lot of possibilities in this new context. The same, having all those other processes happening at once with states that are also parts of the system. So all that just to say that the Advisory Opinion 23 has had a spiral effect, and we are already seeing the impacts on the ground in countries, on educations, on cross-fertilization amongst courts like the European Court of Human Rights and others. And the IUCN contribution to this new process brings a lot of possibilities in the different realms that I have already mentioned and that the colleagues that have spoken have mentioned. So I think that it's great that we're all going to be able to coordinate these efforts and provide some input based on the 2030 Nature Program, on what has been done before, including by the specialist groups and scientific bodies, like it was done before in the case of the marine environment for the previous opinion. So thank you very much.
Thank you. Thank you very much, Claudia, for this brilliant presentation. In the spirit of cross-fertilization and coordination, I would like to take advantage of the fact that Nilufer and Cymie are with us to invite them to react to what we heard just now. And then, Claudia, also invite you to have a look at the Q&A in terms of some of the elements that have been raised by some of participants. I saw an expression of wanting to engage by some of them, a specific question as well, in terms of experience sharing that you might want to react to. But first, Nilufer and Cymie, please. Thank you.
Well, first of all, Claudia, congratulations. You do incredible work, and you have been a leader on these initiatives. Actually, you were a little too generous in your praise of me. I think you deserve a lot more. But I think you really outlined the impact, and I think this is ultimately what we're looking at. And those are some of the things in the question is what's going to be the outcome, what's going to be the influence, and it does have. It doesn't mean that at that very moment the earth will shake, but I think that you have really given an example of the influence of the Inter-American Court, the cross-fertilization, and that. So hopefully this will continue. And I think also just looking at the utility of, bottom line is that you have states seeing the utility of going to these different courts to find solutions, and that's very important. And now you have two important experiences at the Inter-American Court. So Cymie might have something to add.
If I may, I actually have a question, which is how, if you don't mind, Claudia, and maybe Christina, my question is, when an international court or some form of customary international law is stated in an authoritative way, countries take that on board within their own legal systems in different ways. And for some countries, it's more or less directly relevant to their legal process. So I guess my question for Claudia is, given the Inter-American Court's specific membership, is there something particular there that it would have more force within the member states? And Christina, if you're willing, because of your work on the Global Pact, if you were willing to make a comment on that, I'd appreciate it.
Well, thank you, Cymie. Actually, it's the question that you have posed is very interesting, and it relates to something that someone just asked in the chat. So it's very relevant. The weight that the Inter-American system has and the decisions of the system has on varies from countries. There are 25 countries of the 34 member states of the OAS that are party. The Caribbean is not widely there, but there are many CITES countries that are there. But because, again, of the jurisprudential dialogue and the different processes that are going on in terms of control of conventionality, in the region, the decisions of the system have a lot of impact on the ground. And I will give you the example of Mexico. Mexico, by a resolution of the Supreme Court of Justice following the constitutional reform that it was widely a human rights reform, established that all of the decisions of the Inter-American system are binding for Mexico, regardless of whether the Mexican state is a party in the case or not. So there's a case, for instance, with regards to prior informed consent and consultation that happened a few years ago, in which Mexico had not regulated the consultation with local communities and indigenous people. And the court said, well, this is not regulated. What we're going to do is that we're going to follow the Saramacca decision from the Inter-American Court. And this is the process based on what the court said. So there is an impact, and there's also a ripple effect because Mexico, for example, participates in the Ibero-American Justice System, in the Summit of Justice Conferences, and all the countries work together. I always like to show this little book that was done with support of the Commission and the Global Judicial Institute and others, and the Ibero-American Judicial Summit, signed by all the presidents, the chief justices of Supreme Courts of the region, with the principles that they find relevant for adjudication of cases that have to do with the environment. So I think that there's a lot of cause to be optimistic on what the impact of this decision can be, and how, by having these three parallel processes, we can work together on fostering the synergies and making sure that that level of ambition that the global community wants can be reached.
Thank you. Thank you very much, Claudia. As we are nearing the end of this webinar, I was wondering if there was any specific other questions that you may have identified in the Q&A that you wanted to address, Claudia, at this stage?
So just, you know, very quickly, there's a lot of reference on the principle of intergenerational equity there. And I think that this is an innovative aspect of the new request with regards to the rights of children. And I just think that there was a very good suggestion made previously in terms of looking at previous jurisprudence and legal precedent in that regards. And we just have this new commentary issued by the Committee on the Rights of the Child. I think that there's a lot of contribution by IUCN members on this topic, which goes to the other question about how can you contribute to this process. And we're looking forward to engaging on Christina and your leadership, commission members to support all these processes, and in particular the one on the Inter-American Court. So I'm looking forward to being in touch.
Thank you very much, and so are we, very much so. Christina, I believe there was a question that was specifically addressed to you from Cymie, and you might want to also seize the opportunity to reflect more broadly on what I personally believe to have been a very successful and informative webinar. Thank you.
Absolutely. Thank you, Ayman. I briefly addressed Cymie's question, and I have some more general comments that I'd like to share. Cymie, I think that the question of the Global Pact is something that, you know, it was an initiative that raised a lot of awareness around the fragmented nature of international environmental law in particular. And although it didn't go very far, not you know, in the context of what the initiators had in mind, I think what we are having now is an opportunity, if it goes right, for creating consistency, having three different advisory opinion processes, more or less in parallel, no, not yet, is an opportunity to find out how the different bits and pieces of international law could fit together. We don't know if this is going to happen, but it is an opportunity wide open. And if we have conscious judges out there on the benches, they may grasp that opportunity also to give some more general input into the architecture and framework of international law on the environment in particular. But because we're running out of time, I really would like to share a couple of reflections. First of all, coming back to the intention of this webinar, well, one intention was, of course, to shed some light of the work of the IUCN World Commission on Environmental Law in that particular field. We are an volunteer expert network with about 1,000 members plus worldwide that chip in their spare time into our initiatives. And we would like to thank all of them in this way for participating, listening, and spending some of their energy and time with us. The second initiative, or the second objective, was to give an overview and look across these different 3 initiatives that we currently have. There may be more to come. There may be something in Africa that is in the making with the African Court on Humans and People's Rights. But what we currently know of the initiatives is something that we wanted to look at in comparison. And I think we achieved that goal and gave that bird's eye view of these different initiatives as they are out there. But it's also kind of internally within WCL, because we have different teams working on these different initiatives. It is good to bring everyone together and show and share our views and our work on these different submissions. What I've heard for further consideration, and we will have additional webinars that go into more detail on each one of these initiatives, is first and foremost the role, what I said in the beginning, how do different bits and pieces of international law fit together? What role does the Paris Agreement play in the interpretation of the law of the sea, or human rights law, or customary law? There is a customary prohibition of causing significant transboundary harm, as we already heard. At its core is a due diligence obligation, a standard. But how to interpret that due diligence standard is something that is wide open. And here the Paris Agreement may play a role in interpreting the duty of care under customary international law. But these are questions that we haven't really touched upon yet, but we may come back to that. Another one is the issue of the science-law interface, which we only addressed and said that the IUCN has a very important role to play, and it does, of course. But how exactly is it playing out, and how exactly can we help the different initiatives with the added value that the IUCN can bring in these global discourses is something that we might come back to in the future. And one pertinent issue is also that breaking up confines of time and space, in particular future generations, obligations to those that are young today, grow into the future, or those that are not even born yet, also global perspectives of justice. These are pertinent questions which still would require more reflections and deeper discussions. In any case, I would like to thank everyone, both joining us online, but also the speakers that have been with us here today, for your work on these issues inside and outside the IUCN WCEL, and for the work that you will be doing in the next couple of months and years to come, because it's an important moment, it's an opportune moment in time to raise the role of law and the rule of law in addressing one of the, maybe the most defining challenge of our time. And with that general thank you to all of you, I give the floor back to Ayman. Thanks.
Thank you very much. I can but echo this eloquent thanks that Christina shared with all of you. Thank you very much indeed to everyone for having engaged, supported this particular endeavor, and also preemptive thanks in terms of the work that is still to come. Thank you very much to Roberto for his support, for his commitment in making this event a reality. Thank you to all the speakers. Thank you to all the participants. Thank you to Grethel, our dear friend at the IUCN Secretariat, for her constant support. I was just reflecting that a few days ago, we were together in the United Arab Emirates in the context of the IUCN Council meeting. And a few days ago, again, some of us had the opportunity to visit the Al-Wathba wetland reserve, where we got to see thousands of beautiful flamingos. Of course, as I'm not a member of the Species Survival Commission, I do not know as much as I would like to with regard to flamingos. What I do know, however, is that they tend to congregate in thousands and sometimes in millions. And I think this is to a large extent the power of the Commission. The World Commission on Environmental Law is our networks and is the expertise that each of us brings to this important endeavors. In the context of today's webinars, the three advisory, the three AOs that we'll be working on and that we'll be building on in other webinars yet to come. And please stay tuned, following us on social media, as we'll be announcing those webinars that will be co-constructing with our with the IUCN Secretariat, of course, as well as with our specialist groups and steering committee. Thank you very much again for your time, and see you soon. Bye, everyone. Take care.